Hello, everyone. Thank you for joining me. I'm John Belitis, and I chair the Labor and Employment Department at Jennings Strauss in Phoenix. And we're here together online today to discuss the impact of the Great Resignation. I'm really excited that you were able to join us. Before we get started, I want to just run through a few housekeeping items. If you have questions today during the course of the discussion, you are free to use the chat button in Zoom. We have some people in the background who are going to manage the questions. And if I can get to the questions during the course of the discussion, I'll do that. Otherwise, I'll try to get to them at the end. We are going to end promptly at noon today, so all of you can get back to your days. So that if we don't get to a question that you ask, because we run out of time, please feel free afterward to reach out to me. You and I will have a one-on-one offline discussion about whatever it is you need to know, and we'll get your questions answered. The second item involves the recording that we're making today. The presentation, the discussion is getting recorded. And next week, probably toward the beginning of the week, everybody who registered will get an email message from our marketing department that will include a link to the recording as well as a copy of the PowerPoint slides. Feel free to send these items to as many people as you like. If you know somebody who couldn't make it today, or if after the discussion is over, you think a colleague or a friend of yours would benefit from seeing some or all of it, distribute it however you like to as many people as you like. We'd like to get the information out there. And then finally, for attorneys who are participating today, the discussion is going to qualify for CLE. It's going to be 1 hour of standard CLE credit. If you are interested in taking advantage of that, please just send me an email message after the presentation concludes. Our marketing department will get a CLE certificate to you so you can take advantage of that. All right. So with that, we're going to start the slide presentation and get into the discussion. You know, the Great Resignation is something that has been reported on widely for quite some time, right? Let's advance to the first slide. The data on this are fairly remarkable. You know, last year, about 50% of American workers either thought about leaving their jobs, considered a career move. A lot of people did end up separating from their employment on their own. And among those people who left or were contemplating leaving, many of them felt overworked, underpaid, and because of that, less loyal to their current employers. What I want to talk about today is not the phenomenon itself, because, like I said, the Great Resignation is something we're all familiar with. Just talking about it as a phenomenon would be somewhat of a waste of time. What I wanted to do is explore a little bit briefly what might have motivated some of these people to think the way that they were thinking and to behave in the way that they were behaving. And if we can consider what has motivated people to engage in this behavior, quitting, thinking about leaving, thinking about making a change, I think we then can start to be able to predict what risks or problems may arise in connection with the phenomenon itself. And we all know, you all know well enough that if you can predict a risk or a problem and be proactive about it, you're going to be much better off than being surprised by it at some point down the road. You'll be able to hopefully mitigate your liability if you're thinking about these things in advance before they catch you by surprise, right? And what's important here is that you all may have considered or thought about some of the problems and risks that we're going to discuss today over the years, sort of in vacuums, meaning, just alone, episodically, okay? What you might not have done is you might not have connected the dots and thought about the fact that a movement like the Great Resignation could predictably result in some of these risks and problems, okay? And that's what we want to try to highlight today and discuss, so that you'll get some insight into this that you might not have otherwise had. So let's advance to the next slide. So talking a little bit about motivation, a lot of us for like a couple of years, were isolated. We were locked down. People are sitting in their homes or their apartments, kind of staring at the walls. And I think this gave rise to an opportunity for a lot of folks, a lot of workers, to reflect on things and contemplate stuff that they just may have never reflected or contemplated on before. In the pre-pandemic normal world, we didn't necessarily do a lot of deep reflecting. We were busy. We were, going about our business. And then all of a sudden, we're isolated. We're by ourselves. We have a lot of time on our hands. And I think a lot of workers started thinking about, their lives and their careers, whether they were, somewhere in that as successful as they thought they would be by this point in time, whether they were satisfied with their jobs, satisfied with sort of how their life was going. And in the middle of all this, of course, we know that a lot of these people were engaging in side gigs and side hustles, either because they had a lot of time on their hands, because they're sitting at home alone, or because they needed to supplement their income. Some of them were furloughed, some of them were laid off, and they're locked down. And so they started to engage in these sort of secondary jobs. And the thing is, a lot of them found out through the course of this process that they might be able to make more money, as much or more, engaging in their side gigs or side hustles than what they might have been making in their traditional job before the pandemic started. I think this came as a surprise to a lot of people. And I think that led to an idea for a lot of workers that when the smoke cleared and everything sort of went back to normal, they were going to give serious thought to going out on their own, to maybe becoming their own boss. And I think it was an exciting proposition for some of these people. They wouldn't have to account to anybody anymore other than themselves. Self-employment is something that I think intrigues a lot of workers, but many of them just never take that leap. Well, I think the time alone and the reflection and contemplation during the pandemic, I think, convinced a lot of people to try it. And what they were making through what they were doing, I think, gave them a sense that the grass could definitely be greener somewhere else, maybe doing something on their own. And during the course of this whole period of time, there was a lot of friction developing, I think, between workers and employers. There were arguments about vaccines and masks and reduced hours and furloughs and, medical exemptions, religious exemptions. And a lot of people, I think, got to the point of thinking that they almost felt compelled to leave because they just became so unhappy in what they were doing up to that point. Okay. So let's go to the next slide. And I think you can take all of what I just described if you want to buy into it. I mean, this is my theory, okay, about sort of what happened. If people are thinking this way and experiencing these things, what could we predict that they may do if they leave their employment with you? If they do decide to make the leap, venture out with the new opportunity, what might they be tempted to do when they embark on that? Well, keep in mind that although, for example, self-employment is a very exciting proposition for someone who's never tried it before, it's also very scary, right? And for workers who decided that they were going to leave their traditional jobs and do something different, yes, they were excited about it, but to be fair, they wanted to succeed. They didn't want to fail, right? And if you have a worker leaving to embark on something new, maybe something that he or she has never done before, with a little apprehension and a desire to succeed, they may be tempted to take your stuff with them when they go, right? They may be tempted to take your proprietary information, your trade secrets, your client lists, your vendor lists, and so on, right? Because they think that maybe they thought that would give them an advantage. Maybe they thought it would level the playing field. Maybe they thought it would give them a head start in venturing out onto what they were going to do next. And this created an interesting predicament for a lot of employers, maybe some of you as well. And that is the prospect that you may have to seriously consider enforcing restrictive covenants that you have with some of your departing workers. Now, I know that not all of you have these things, and for those of you who do have restrictive covenants in place for workers, they may only apply to a handful of them, maybe upper management, maybe C-suite. But, you know, the Great Resignation was an equal opportunity phenomenon, and it still is. It impacts a lot of people, including people at those levels. And the odd thing I think that cropped up for employers when they're faced with the proposition of maybe enforcing restrictive covenants is the fact that when they put them in place, they never thought that they'd have to enforce them. You know, a lot of employers, maybe some of you are among them, implement restrictive covenants not because you think you're ever really going to have to enforce them. You implement them as a deterrent, right? You implement them so that the worker who leaves, who has comparatively less resources than you do, if you wanted to engage in a lawsuit with them, is going to think twice about, you know, venturing out of their lane. They're going to keep their nose clean because they don't want to be saddled with an expensive lawsuit that you might bring. They can't withstand it. And so the deterrent effect of restrictive covenants, I think, is by and large what a lot of employers think about when they implement them. And what that means, though, if all you're doing is worrying about or thinking about deterrence when you implement them, creating leverage, not necessarily going to the mat with them, you may not invest a lot of resources in them when you implement them, okay? What I mean is, well, who knows, maybe you pull them off a LegalZoom, maybe you just put them together yourself, because you're not thinking that you're ever going to file a lawsuit with them. You're thinking that you're going to have them in the background so that employers think twice about doing something wrong after they depart. Well, now maybe you're pulling them off the shelf and dusting them off and seriously considering trying to enforce them because you have to. You know, maybe these people who are leaving are violating them. And you pull them off the shelf and take them to an attorney, and you may find, and hopefully it's not the same attorney who drafted them to begin with for you, but the attorney may say, you know, you're going to have some issues with these or with this covenant because there's going to be an enforceability problem. It's just not written correctly. It's not drafted correctly. You all may know from dealing with me or lawyers of your own or my department over the years, restrictive covenants in Arizona, for example, have to be written in a very deliberate, discreet way in order to make them enforceable. Because there's public policy against why they exist. Judges don't like to enforce them because they think they impact people's ability to make a living. So if you pull them off the shelf and your counsel says, hey, you know, you didn't really create the gold standard restrictive covenant here when you implemented it. You probably thought you were never going to have to enforce it. If you need to start thinking about doing this, you're probably going to have to replace these with things that are better, new and better. And if that's the position you're put in other words, maybe being put in the position of having to think about rolling out a new set of enforceable restrictive covenants, then you have to think about what you're going to do when you roll those out to your existing workforce. And that's the point I'm getting to here. If you have a set of restrictive covenants that you're going to abandon, and then a new set that you're going to create and roll out and implement, when you go to your existing workers with those new covenants, you're going to basically be saying, hey, we're abandoning these old covenants. We're going to implement these new ones. You need to sign off on them. Well, you all probably know that, you know, the difference between an enforceable contract and just a promise is the fact that some quid pro quo needs to get exchanged between the parties in order to make that promise enforceable, right? You know, if I promise to come over to your house this weekend and wash your car and I don't show up, you can't sue me. But if you give me some money when I make that promise, then I'm obligated to come over and do that for you. And when you roll out a new restrictive covenant, you're going to need to give those workers something in order to make it enforceable. right? A lot of employers take the position, well, what I'll say is your continued employment is going to be the consideration to enforce this, right? Your continued employment. You're working here, and if you want to remain here, you need to sign off. And imagine a situation where you have 10 employees and you roll out these new restrictive covenants, and 8 of the employees say, sure, I'll sign them. Where do I sign? And 2 of them say, I'm not signing this thing. And those 2 people who won't sign happen to be your best workers, okay? Now you're in a bit of a bind, because if continued employment is the consideration to support the covenant, you then need to fire the 2 people who won't sign them in order to make them enforceable with the 8 people who did. Otherwise, if you let the people stay who don't sign, when you go to enforce them against 1 or more of the 8 people who sign off, when they get a lawyer, they're going to say, no, there was never any consideration for this covenant, because the former employer at that point never had any intent of firing anybody who didn't sign. And then the whole thing falls apart, whether it's written correctly or not. What I have told clients over the years, which is the last bullet point here in this slide, is if you want to avoid this problem, your better option is to pay people to sign the new covenants. Take my hypothetical before. You've got 10 people. We'll switch the facts to make a point. You roll these things out to 10 people, 10 employees, and you say, we're replacing our old restrictive covenants. You need to sign off. And you say, everybody who signs gets $500. All right. The 8 people who want to sign them say, where's the money? I'll sign. Where do I sign? And the 2 people who maybe happen to be your best employees say, I don't want the $500. I don't want to sign this thing. Well, then you're good. Pay the 8 people the $500 and they sign. Let the 2 best employees stay and they don't sign. They don't get their $500. But you know what? Then you don't have a consideration problem with that new covenant. Okay? You'll be able to enforce it against the 8 people who sign without having to worry about the consequences of letting the 2 people who won't sign stay. That's why, in my view, paying cash for new restrictive covenants for people who are already in the course of your employment is a better option than creating a predicament for yourself when you rely on continued employment, okay? Now, I will say, I think all of you would have received this from me a few weeks back. I sent around an alert to you all about a new FTC rule that was proposed just a couple days before, the Federal Trade Commission. And this is all about, a Democrat administration, right? We have Biden in the White House. All of the pro-employer stuff that got created and rolled out during the Trump administration is all getting reversed now with the change in leadership in the White House. And we've learned that the FTC is proposing a rule, which is now in the public comment period, that would make it unlawful for any business, whether you're talking about an employee or an independent contractor, to create or implement a restrictive covenant for them. And it would invalidate all existing restrictive covenants. I think in the alert that I circulated, I said it was radical. I think it's extremely radical, and we're keeping our eye on it. The reason I bring it up now at the conclusion of this part of today's discussion is this whole thing that we're talking about could potentially become moot, because if the FTC rule actually gets formalized and becomes law, none of you guys is going to be able to use restrictive covenants anymore. It won't be lawful for you to implement them or force them on anybody. So keep an eye on the news media for that. And when we hear anything new about it, we certainly will be updating you, but it is something to keep in mind that is going on in the background right now. So let's go to the next slide. We talked about what people might consider doing when they leave, taking your things, violating covenants, and so on. But up to that point, in the run up to that point, what is going on in your workplace? Okay, people feel underpaid, people feel overworked, people feel less loyal to you as employers. So what can we predict is going on as all this percolates, as people in the run up to them leaving or resigning? Well, they're grousing, right? They're just bitching about stuff. They're not happy. This is the friction that we talked about at the very beginning that has developed between employers and employees during the course of the pandemic over all of those issues. And when employees grouse and complain, it gets on employers' nerves, particularly if they do it on a platform that is visible to others, visible to non-employees, like social media, okay? And here's something you all need to keep in mind. And for those of you who are well aware of this and in tune with it, I'll sorry if I'm boring you or telling you something you already know, but this activity of complaining and grousing and bitching is a federal right that non-supervisory employees have in the workforce. They can complain about you, they can express their dissatisfaction, they can do it in a way that is visible to others, meaning people who aren't employed by you. They can use profanity, they can be rude, they can call their supervisors names. All of that is protected. You can't retaliate against them for it, you can't discipline them for it, and if you do, you risk ending up with what we call an unfair labor practice charge, okay? This all arises out of the National Labor Relations Act, federal law that was passed, it's almost 90 years old now. It was passed, I think, in 1935, okay? The law gave employees this right to engage in what we call protected concerted activity, which is a term that just simply means they have the right to communicate with one another about wages, hours, and working conditions, non-supervisory personnel, whether they're unionized or not, it doesn't matter. And what the National Labor Relations Act says is if you have, as an employer, chill that or retaliate against people for engaging in that, you have engaged in unlawful activity. And this is what happens. If an employee feels as though he or she has been retaliated against for doing this, maybe you discipline them, maybe you suspend them, they will file, their remedy is to file an unfair labor practice charge with the National Labor Relations Board, which is the body that Congress created to enforce the National Labor Relations Act when it was enacted back in the 30s. And no disrespect to the board, but the board is not a place you want to be as an employer, okay? Some of you may have had this experience with unfair labor practice charges, maybe some of you haven't. We've litigated a lot of them. And the thing about the board is that all under one roof, you have the people who investigate the charges, you have the lawyers who prosecute the charges, and you have the administrative law judges who decide the charges. It's a one-stop shop, and it's just a plain fact that when you create an agency or a body like this to enforce a law that is orchestrated in this way, it is just inherently biased in favor of the worker and against you. Okay, so you need to keep this in mind. If one of these charges gets filed, it's painful, they're expensive to litigate. You essentially have to have a trial at the National Labor Relations Board. And what I will tell you about the board is much less inclined than, say, the EEOC or the Arizona Civil Rights, or even the Department of Labor, to settle charges or complaints as opposed to taking them through trial. The board is disinclined in most cases to settle. And what that means is a charge like this is going to be expensive for you, it's going to be time consuming, and in many cases, if you have employment practices liability insurance, it may not be covered by your policy. Sometimes it is, but sometimes they're not. So if you have a group of workers who are grousing and complaining, before you pull the trigger to do anything about that, please get in touch with counsel and walk through it. There are some exceptions. I mean, if a worker, for example, threatens violence against a manager or a supervisor in the course of complaining, that crosses the line. That's no longer protected. But the examples of the crazy communications that workers have engaged in that the board has protected are numerous. And you don't want to end up there, trust me. The other thing that really frustrates or has frustrated employers in the course of all this are the workers then who leave, they quit, right? Great resignation, they quit. And then they go to the Department of Economic Security and file a claim for unemployment compensation. And you as the employer are scratching your head going, wait, this makes no sense. Because I know enough that in order to even be eligible for unemployment compensation benefits, right, you have to be separated involuntarily. You have to, that's eligibility. Someone who quits isn't even eligible. And then if you're fired, then the person receives the benefits unless they were fired for engaging in what we call misconduct connected with the work. Generally, people who are laid off for economic reasons, people who are laid off because they're just kind of incompetent, they always get benefits. They're separated as the DES, the Economic Security Act says, through no fault of their own. But people who quit, you never even reach that question, right? Because they're not even eligible. Well, workers have all sorts of workarounds for this. It was a fait accompli. I thought I was going to get fired anyway. My working conditions were intolerable. I felt compelled to leave, right? There are all these arguments that they can make that can flip the script and turn the narrative into, I really didn't quit. As a practical matter, I was fired, okay? And then sometimes you get the determination from a deputy at DES for a worker who quit and filed a claim, and they get the benefits. And that just chafes you to no end. And then you call me and you say, I don't care what we have to do. We're going to challenge this until the cows come home. This person is not going to get benefits. They quit and there's no exception that applies to them. I want to appeal it, right? Look, this is the advice we universally give to all employers, and I want you to think about it if you're faced with this now or in the near future. Don't challenge these things, just let them go. And there are two reasons for this. Well, actually, probably three. One, a DES determination on benefits by statute in Arizona is inadmissible in any subsequent litigation with the worker. It has no precedential value. It's irrelevant and inadmissible. If you let it go and just let them get paid and let that deputy determination stand, it's never going to come back to harm you if you end up in a lawsuit with the worker later. Second, even though the determination is inadmissible and irrelevant, if you appeal it, you're going to end up in a little kangaroo hearing with an administrative law judge who's going to turn on a recording device, put everybody under oath, and take testimony. Okay? The determination never will see the light of day in a courtroom if you end up in a lawsuit with that worker later. The transcript of the sworn testimony is fair game everywhere and anywhere. And let's face it, no one prepares for an unemployment benefits appeal hearing the way they would for a jury trial in federal court. People show up and say things, they operate from the seat of their pants. Maybe they're supervisors, maybe the managers. Stuff gets said that will come back to haunt you in the end, okay? Because people are just not prepared the way you would prepare them for formal civil litigation. You don't want to risk that. And finally, the third reason not to worry about it and to let them go is that unemployment, the whole unemployment compensation system really works just like a car insurance policy or a homeowner's policy. You have a claim or two, you're not paying those claims dollar for dollar out of your pocket. It affects your experience rating, and your premium might go up a little bit, your unemployment insurance tax premium. But it's not material unless you experience a whole lot of claims in a short period of time. So there's plenty of reasons, if you get faced with one of these determinations that irritate you because of a worker who quit as part of the Great Resignation, say, not to challenge it. Don't appeal it. And then finally, and this is just sort of a parting point here in this slide, a lot of people, I think, ended up quitting and leaving because of disagreements over COVID-19 policies. People wanted a religious exemption from a vaccine or a mask mandate. People wanted a disability or medical exemption from a mask mandate or a vaccine mandate, right? Those are all very fertile reasons when someone departs for discrimination charges, right? Either under Title VII for religion or under the ADA for medical and disability reasons. In Arizona, workers have 300 days from the date of the event, okay, to file a discrimination charge. So even though the pandemic has cooled off, we've somewhat returned back to normal for the most part, there's still a half-life for these events. And you need to understand that you may encounter, we have a lot of clients still encountering now, discrimination charges over exemption requests under Title VII and the ADA that headed south, that are now being investigated by either the EEOC or the ACRD. Okay, let's go to the next slide. So you kind of are in between a rock and a hard place a bit as an employer, because you have all these people leaving potentially, right? But you need to maintain critical mass at your workplace in order to operate efficiently and profitably. I mean, you need bodies. I mean, how many of you have gone out to a restaurant in the last 6 or 8 months, and you're waiting at the door to get seated, and you peek in and half the tables are empty, right? And you say to the hostess, why are we waiting? And the hostess says, because we don't have servers to staff those tables, right? This is a problem more heavily for a lot of particular industries, hospitality, food service, bar and restaurants in particular. But it's a problem I think that everybody's experiencing to one extent or another. It's hard to get people to work. People leave, and then you have a hard time hiring people. So what do? Well, you try to retain people, right? Maybe you dangle a carrot. Maybe you offer a retention bonus. Maybe you offer some additional perks to get them to stay. So you don't end up in a situation where you're practically forced to close down because you don't have enough people to work for you. Keep in mind, when you engage in a retention program and you're going to offer carrots to people to get them to stay, you have to take a close look at who you are offering the carrots to, okay? Because if let's say you feel like you need to retain a certain segment of your workforce, maybe they're managerial, and you have a deeper bench at the grassroots level, but you're losing a lot of managers. And so you offer retention bonuses or perks to the managers. And then what happens, just say hypothetically, if your management group is primarily comprised of non-minorities and your grassroots group, your frontline workers, are much more heavily comprised of minorities? Well, then unwittingly, there's no bias or ill intent behind any of this, but unwittingly, you have just created a disparate impact problem. And one of those grassroots workers who didn't get offered a retention bonus is potentially going to file a discrimination charge against you. And then when you go back and look at what you've done, you'll be really disappointed to find that, oh my goodness, I offered a bunch of bonuses to basically a bunch of non-minority employees, and I boxed out our frontline workers who are primarily minorities. And you've made your bed at that point. You're going to have to sleep in it, right? So the point is, and we advise you about this with discipline too, when you're considering disciplining people. Always look at sort of who you're talking about, who you're targeting, and who's going to be affected. You don't want to unwittingly create a discrimination problem for yourself through a retention program that ends up coming back and biting you, okay? So let's go to the next slide. You know, the funny thing is, you may end up trying really hard to retain people who maybe by definition are your worst workers. Because, you know, the people who are motivated, the people who, you know, leave to take that grass is greener opportunity, become self-employed, go out on their own, embark on an exciting new opportunity, they're not the lazy workers. They're not the unmotivated workers. They're the go-getters, right? Who ends up staying behind? Well, they're corollaries, right? And so it's for a lot of employers, I've seen that the need to maintain the critical mass to stay open or to operate is they have to weigh that against who they are retaining in order to do that. And it can create an awkward situation for you, because these people who end up staying, they may not only be the lazy ones and the unmotivated ones, but they may be the ones who are inclined to work the system. You know, they may be the ones who know that they've got leverage over you because you can't afford to lose them. And so this creates it draws a line for you that is very difficult to walk. And we'll look at the next slide, and I'll explain what I'm talking about. If you then have to deal with this remaining workforce, who may not be the cream, they may be the bottom of the barrel, if you will, you probably are going to still have, or maybe have more occasion to have to counsel and discipline workers, because they're not your best workers. The people who you end up retaining or the people who end up staying, a lot of them aren't. And you know from talking to us over the years that the most important thing, even in an at-will state like Arizona, is to document disciplinary problems. Because, you know, you can have a perfectly good reason to let somebody go, and in an at-will state, you have a right to do it. And when they file a discrimination charge, and then you end up having to explain your reasoning for letting them go, if none of it's documented, it looks like you're making it up after the fact. It looks like pretext. So you need to keep documenting. But the predicament that you're in is you want to document disciplinary problems, and you want to counsel these workers, but you don't want to do it in a way that will force them out the door. This is the line that I'm talking about, the fine line that you have to walk between maintaining those disciplinary files, right? And wanting to make sure that you retain workers. So it's a sort of a delicate balance is what I'm saying that you have to strike, okay? And you need to pay attention in the disciplinary process, as I said before, to who you are disciplining, just the way you would in a retention process about who you are rewarding or incentivizing to stay. Whenever you go to discipline somebody, make sure you take a look at, we advise you about this all the time. Think about other people who committed the same type of misconduct or did the same thing, and how you discipline them in the past. And make sure that you just didn't happen to treat a non-minority more favorably than the minority you're getting ready to discipline now, okay? You always need to keep that in mind. Now, here's another, an interesting update for you that is not, this is not included in the slide, but this just occurred last week, and I want to tell you about it. In the context of this discussion that we're having about loyalists who stay, who may need to be disciplined. A lot of times when you get to the end of the line with one of these workers, as much as you want to keep them on board because you need the bodies at the workplace to work, you may at some point need to cut them loose. And a lot of times when you guys come to me, one of the options I suggest to you is, if there's a potential problem that could result in litigation later, we advise you, hey, maybe you want to pay this person something in return for them signing a severance agreement or a separation agreement. Extract a release of claims from them in return for the severance, the payment, and then you won't have to worry about it, right? So when you sit the person down to do their exit interview, if you take our advice in a particular case, the conversation would go something like, hey, it's just not working out. We're going to have to part ways. We know that you're going to have to, you may need a bridge to your next opportunity. We'd like to help you with that. We'd be willing to help you with some severance, but if you want to do that, just to close out our relationship with you, we'd like to sign a separation agreement. It's kind of like just sort of a matter of formality in closing a personnel file out. Would you be interested? And if they take the bait, right, then you end up paying them something in return for signing one of these agreements. And then you can breathe a sigh of relief, because that agreement will have provisions in it that will involve the employee releasing his or her claims against you. Well, just last week, the NLRB, the board that we talked about toward the beginning of the presentation, came up with a new rule that in which the board basically takes the position that non-disparagement provisions and confidentiality provisions in severance agreements are unlawful because they impact a worker's right to engage in protected concerted activity. In other words, if you say in a severance agreement, you cannot badmouth me, you can't disparage me, The board is now taking the position that that infringes on that right of the worker to grouse that we talked about earlier in the presentation. This is another radical development because we always, you know this, guys, from severance and separation agreements that we've prepared for a lot of you. We put non-disparagement and confidentiality provisions in all of them. And what this board rule is basically saying now is you can't do it, because if you put a non-disparagement or a confidentiality provision in a severance agreement, you are committing an unlawful act under the National Labor Relations Act. It's crazy. We think there probably is a workaround to this. I mean, my suggestion, as this comes up, as we start drafting severance agreements in this post-rule era that I just explained, is I think we still put some form of maybe a watered-down, milder non-disparagement confidentiality paragraph or provision in the agreement, and then in boldface we'll include a disclaimer that says this provision is in no way intended to infringe on the employee's right to engage in protected concerted activity under the National Labor Relations Act. Now, we'll have to see how that goes, if it gets tested. But this is a strange development. And, one point I wanted to make about the board, this is a good example of why the board is a bad place to be. The board has remedies that it can give to employees who file unfair labor practice charges that go way beyond any remedy that the employee could get in regular civil litigation. Normally if an employee sues you for discrimination or something, they can get front pay, they can get back pay, they'll get some compensatory damages, maybe some time for their emotional distress. Once in a while, very rarely, they will ask for punitive damages to punish you. But the board can go way beyond that. The board can force you to reinstate people. The board can force you to pay people. The board can force you to post things in your workplace about how evil you are as an employer. The board can force you to rewrite your policies and procedures. And in this instance, the board is basically telling you, oh, you want to do a severance agreement? We're going to tell you how you can and can't write it. It's extraordinary. So as you move forward, when you have a need to think about entering into a severance or a separation agreement with a worker, when you come to us, for sure, we're going to discuss this. If you go to somebody else, if they don't bring it up, some other attorney, make sure you ask, hey, how are we going to deal with this board rule about confidentiality and non-disparagement in a severance agreement? Okay, very important as of last week, because this rule theoretically became effective immediately. There's no grace period. So let's go on to the next slide. Well, if you're losing workers and your critical mass is shrinking, what else might you do? Well, you might engage in a recruiting campaign, right? Keep a few things in mind if you engage in a recruiting campaign. If you use a third party to run background checks or what's called a consumer report or an investigative report on an applicant for a new job, you're not doing it internally. You're using a third party to do it. You then have certain obligations under the Federal Fair Credit Reporting Act, okay? I'm not gonna go through them all here because we have to be efficient with time. There are things that the FCRA requires you to do and prohibits you from doing. If you're using a third party to run those things, be sure and check in with counsel about what you need to be doing to comply with the disclosure obligations and other things in the Fair Credit Reporting Act when it relates to consumer and investigative reports, background checks on potential employees, applicants. If you use social media to vet applicants, social media is a gold mine for vetting potential employees, right? Keep in mind, it is also fraught with problems. You do not want the person who's going to make the hiring decision to be the person who is mining social media. Why? Because there's a lot of stuff that people put on social media about themselves that you should not be considering in deciding whether to offer somebody a job. You don't want to be considering what church they're going to on Sunday or what certain types of causes or groups they belong to, because they may involve protected characteristics under Title VII, right? If you're going to use social media, what I would recommend that you do is you take a person, put them in a cubicle, create a firewall, wall them off from everybody else, say, your job is to mine social media for people who apply for jobs with us. Here's the stuff that the hiring decision maker should not be considering. Cull all that information out and then deliver the rest of it to the hiring decision maker. So the dossier or the file that the person gets on the applicant to decide whether to hire them, all of that stuff that should not be considered has been extracted by your social media person. That way, if the applicant who doesn't get the job says, oh, I think you didn't give me that job because you saw on my Facebook page that I'm struggling with a disability, that may not be obvious. You can say, that's impossible. You know why? Because the person who made the decision not to hire you never looked at your social media. Someone else did, and all that information was extracted before the person who made the hiring decision, or in this case, the decision not to hire, was informed. Very important, something to think about. Next slide. You know, the end result of all this, sort of like the new world we're living in, is the fact that a lot of people are going to be working remotely. Workers, I think a lot of you must have experienced this. They have this leverage over you now. So you're in the recruiting phase, you're in the retention phase, you know, you're trying to maintain the size of your workforce, you're trying to maintain your critical mass, and you've got workers coming to you saying, I want to work from home. And you're tempted to say, well, no, the pandemic's over, we want you in the office. But you know what a lot of those workers are going to say. Okay, fine. You don't want to let me work from home? I can just go down the street, get a job with your competitor or some other employer. They'll let me work from home. So goodbye. And then all of a sudden you've lost another worker. Employers, because of the need to maintain that critical mass in their workforce, are caving in to remote work. And in some cases, they're caving in whether they like it or not, because if they don't give this to the worker who essentially demands it, they're going to lose the worker. And that's the whole point here, right? We're talking about the Great Resignation and the fact that you're either trying to retain people or hire them. You don't want to be losing them. Well, what this gives rise to is managing the question of managing the remote workforce. Okay, this platform that we're on today, Zoom, has been considering embedding AI and biometric features into the application, so that when people are on a Zoom event, employers will get feedback from the application, from the platform, about cues that the platform is reading about what these people are or aren't doing. You may have heard about this with Amazon drivers. You know, the Amazon drivers in the Prime trucks are like constantly monitored by 3 different cameras at 3 different angles. And Amazon is using AI technology, not real people, to monitor their activities when they're in the vehicles. And the problem is a lot of these AI tools misread cues. Like a driver in a truck can yawn and the application misreads it and turns that into a disciplinary notice. And a lot of times through this technology, a worker in one of these jobs where AI is monitoring him or her will get a disciplinary notice or a counseling notice that essentially is generated by a machine. No human is ever involved in it. The AI technology is monitoring them. The AI reads a cue. The AI translates that cue into a counseling document, and the counseling document then is emailed to the worker. And the worker is like, what's going on here? I yawned. And I will tell you that the ACLU and other groups are taking the position that this technology is inherently discriminatory, because it is going to, they claim, it's going to result in widespread discrimination against minorities and people with disabilities because of the risk and the way in which the AI technology is prone to misread cues. Okay, so my advice to you is, if you have to implement remote monitoring technology because you have a lot of people working from home. When you do your due diligence about what products you are going to consider, which ones you're going to vet to use if you're going to use them, do your research, look at the history and dig down deeper online about the technology you're considering. Don't buy and implement a product that has had issues like this with it. Try to find a product that has had more benign, more successful results. It hasn't been taken to task for misreading cues, because it's your technology when you buy it and implement it, right? If you discipline a worker or separate a worker because of what your AI technology tells you to do, and it was a bad decision, you're stuck with that. And if that person files a discrimination charge against you and claims that your technology is prone to misread cues against minorities, you're not going to be able to, your defense isn't going to be, well, that's the technology's problem. No, when you buy and implement the technology, it's your problem. You become the technology, okay? So do your research. Look, it is 11:52, okay? So I haven't seen any questions yet because I've been looking at a full screen of slides. So I don't know whether we've had any. Maybe we haven't, because now I'm looking at my screen. I don't see any questions there now. As I told you at the beginning, if you have them and maybe maybe they're just not something you want to raise during the course of a presentation, but you would rather talk about them offline, that's no problem. All you need is to shoot me a message or give me a call. We can chat about whatever you like in relation to the presentation today or anything else. And in the department of anything else, I do want to share one more thing with you in the final moments that we've got. It doesn't relate to the impact of the Great Resignation, but it is something that has occurred. And I think I put it in the category of what I called sleepers, because I don't know that a lot of people paid attention to this. Many of you may know about it, some of you may not. In December, of last year, President Biden signed into law two significant new bills that Congress passed: the Pregnant Workers Fairness Act and the Providing Urgent Maternal Protections, or PUMP, for Nursing Mothers Act. These two laws are going to have a significant impact on your obligations to pregnant employees and nursing mothers in the workplace. They don't cover all employers because, like Title VII, the Pregnant Workers Fairness Act has a 15 or more employee threshold for it to apply, and the PUMP Act is like FMLA. It's 50 employees. All right, but these two laws combined go well beyond what Title VII and the Pregnancy Discrimination Act and the ADA did as far as requirements with you folks in the past. There are a lot of new protections in them. There are a lot of new provisions that are more aggressive in terms of how they protect nursing mothers and pregnant employees, and you should be aware of them. The Pregnant Workers Fairness Act will become effective on June 27th of this year, okay? So you'll want to get some counseling on that. The PUMP Act became effective in December. It became effective on December 29, all right? If you don't know about these, you can reach out to us. We can give you a summary of them. And I'm actually considering later on in the year, before June 27, for sure, Julia Atkin and I may put on another webinar that will, in which we'll talk about these laws in particular and get into more detail about them as the June 27 enforcement date for the Pregnant Workers Fairness Act approaches, okay? And maybe by that time, we will have some more information for you as well about the FTC rule, essentially outlawing restrictive covenants, okay? Let me look here. I've got one question and we have 4 minutes left, so let me take a look at it. The question is, how do you recommend the best way to stay hopeful when trying to do the right thing with the various rules that are required to consider for overall healthy employment practices? Well, and look, this is not a self-promotion, right? What I will tell you is, and it doesn't necessarily apply exclusively to lawyers, I would reach out to counsel and collaborate with your attorney to try to address some of these things. And if you're not using an attorney, that's fine too. Reach out to your consultant, reach out to your vendor that maybe provides light employment law related advice to you, because to stay hopeful, you need to have a game plan, people. And you can't create the game plan with all of these things developing on your own. Unless you have a general counsel, an in-house counsel who's really familiar with all this and maybe has a background in employment law, you have to have a resource. And I always view myself as a collaborator with clients, not like someone who's just dispensing advice. So my advice to you to stay hopeful is collaborate with your outside resources, with your attorney, with your consultants, with your third-party vendors. And as you develop game plans to deal with these developments, maybe that will give you it will enable you to feel more hopeful about what you're doing, because you will see yourself developing strategies to prevent problems. And that was the whole point of the discussion today. The whole point of the webinar was to try to key you into some of this stuff that you can be proactive to try to head things off at the pass, right? Someone else is asking for the summary of both of those acts. Please, if you want, what I'll do is I'll send around, I already have something prepared to circulate. If you want it, it's going to be a very light general discussion of those two new laws that I just referenced. And then if you want to get into the weeds further on them, we can do that with you. But what I can send around has more substance than what I described online, because we didn't have time to go through all the bullets about what these things actually, the new things that these laws require you to do. Happy to circulate it, okay? So it's 11:59. I don't like to run over on these things because I know you guys have stuff to do. I don't like to be involved in presentations when something goes on and on past when it's supposed to. So listen, thanks for joining me. Thanks for listening. I hope this was helpful. Once again, you'll get the message with the link to the recording and the slides. The link to the recording also will be on our website in the video section. Please circulate that to everybody or anybody you want to if you think they would benefit from it. And thanks again. Good luck to all of you. Hopefully we'll be talking soon.